to Washington Legal Foundation's 30th Annual Supreme Court Preview Briefing. My name is Glenn Lamey. I'm Chief Counsel of the Foundation's Legal Studies Division. We're pleased to be doing this, as I said, for our 30th year. We are in nearly our 40th year of free enterprise advocacy and education as a public interest group. Those of you not familiar with the Foundation and you're online, please spend a little bit of time with our website. One of the things that we are very active in is filing briefs in the U.S. Supreme Court. We have 4 on the merits briefs so far this year, and we have 3 cases where we are seeking supporting the cert petitions, 2 of which were probably conferenced this past Monday, yesterday. We have not heard about those just yet. Some of the cases that we've filed on the merits will be discussed by our speakers here today. I want to introduce Jay Stevens, who's going to be our moderator today. He's of counsel with Kirkland Ellis here in Washington. He's also chairman of the Washington Legal Foundation's Legal Policy Advisory Board, former senior vice president, general counsel, and corporate secretary of Raytheon. And prior to that, he had a distinguished career in public and private sectors, including serving as Associate Attorney General of the United States. I want to let everyone know who's doing this online. We're going to be live tweeting the program today. The hashtag is WLFSCT if you'd like to follow along. Jay, if you could get us started.
Thank you very much, Glenn. I'm delighted to be here and delighted to share the platform and moderate what I'm sure will be a fascinating and interesting discussion. I was going to say debate, but that's probably just a hangover from yesterday. A discussion between 2 exceptional Supreme Court advocates. I would like to just underscore what Glenn said, and that WLF, Washington Legal Foundation, is very engaged in litigation, particularly appellate litigation before the Supreme Court, but also before many of our circuit courts, particularly and focused on issues of business, of regulatory issues, of free enterprise issues and matters that impact standing, jurisdiction, class action, takings, those kinds of issues where the regulatory environment and the administrative state is impacting how we do business here in this country. It's my pleasure to introduce the 2 panelists today. I will note they will each probably spend 20-25 minutes discussing 3 or 4 cases that they either are involved in or have obviously some intimate understanding of cases that are before the Supreme Court. We're still waiting for the court to announce the results of its conference of yesterday to determine whether or not there are other cases where WLF has been involved on the cert process, whether they will be taken up this term. But they will each divide and take the 3 or 4 cases and provide some insight and comment to you, so you get a sense of what the issues are, what the direction where the courts have been going on this, and why they are important to the free enterprise system and economic liberty. First, Neal Katyal. Neal is a partner at Hogan Lovells here in Washington. He served as the acting Solicitor General of the United States for a number of years, and prior to that was a professor at the Georgetown Law Center. He was one of the, I love to say this, he was one of the youngest professors at the Law Center, and had a really fun and active course load there. Prior to that, he clerked first for Guido Calabresi, Judge Calabresi on the Second Circuit, and then for Justice Breyer on the U.S. Supreme Court. I think Neal will lead off, and then after Neal walks through and talks through some of the issues in the cases he's handling, Daryl Joseffer will take the platform. Daryl is a partner at King & Spalding here in the Washington office, where he heads their national appellate practice. He joined the firm in 2009 after serving as Principal Deputy Solicitor General of the United States, and prior to that as the Assistant to the Solicitor General. Interestingly, they both have a tremendous depth of experience in the SG's office, but ironically, they were, I guess, seriatim in service to the United States one actually assumed the office of the other as they moved through that terrific department. Daryl also clerked for Judge Jerry Smith on the Fifth Circuit Court of Appeals and had some experience in the executive branch where he served as Deputy General Counsel to the Office of Management and Budget. So without further ado, Neal, why don't you take the floor, and it's all yours.
Thank you. It's a delight to be here with all of you, and particularly a delight to be here with Daryl. You know, I was thinking about this last night, watching the debate and the harsh rhetoric, and I just thought it'd be helpful to tell the story of my first minutes at the Office of the Solicitor General on January 20th, 2009. I walked in, and on my desk was a letter, and it was a long letter from Daryl, who had just left the night before the office. And it was a really thoughtful letter about the traditions of the office, about the people, offering his assistance and help in any way, shape, or form. And, you know, that's the ethos of our bar and the ethos of that office, and hopefully of our profession more generally. And I couldn't be more proud to be here today with Daryl. That just showed exactly, I think, what we're all about. And I sure hope and I expect that, you know, President Obama's staff and so on will treat the successors in the same way that Daryl treated me. So we obviously have a term that is in some sense in flux. 8 justices are on the court now. We had the sad news in mid-February that Justice Scalia had passed away. That had any number of effects on the cases that were pending at the time, and those effects continue to reverberate now. It takes 4 votes to grant certiorari. 4 votes out of 8 is more difficult than 4 votes out of 9, just statistically. And then we can talk about all the other kind of complexities maybe a little bit later in this. I think when Justice Scalia passed away, there was, you know, some thought that, oh, the court's going to move dramatically to the left. We certainly haven't seen that yet. If Merrick Garland is confirmed, you know, there'll be any number of effects, but one will be, you know, kind of counterintuitive, which is that Judge Garland is more conservative on criminal issues than was Justice Scalia. And so you see the court moving, quote unquote, to the right should we see Garland replace Scalia. There are any number of interesting questions like that that will unfold, but we're really here to talk about the corporate cases, and you know that's what we're going to focus on. I did want to give you a little bit of data, though, for last term, because I think it does set up nicely this term. So last term they decided 67 cases on the merits after oral argument, and they affirmed in 33% of them. So that's actually a bit higher than usual. The usual average is about 25% affirmance rate. So that's to say that if the Supreme Court grants certiorari in a case that you won in the Court of Appeals, that's really bad news for you roughly 3 out of 4 times. You know, this last term a little bit different, but not tremendously. In terms of unanimous cases, 44% of the cases decided unanimously. That's about average for the Roberts Court. I do think that the chief has steered the court in general toward more unanimous opinions. 2 years ago, he did something, he steered the court, I think, in a remarkable way. Roughly, I think about 2/3 of the opinions were unanimous that term. And you'd have to go back to the year 1940 to find a similar term like that. So I think the chief showed a lot of leadership there. You know, I think we can suspect no matter what happens with that 9th seat, we'll see a lot of that unanimity. In terms of who's agreeing with who the most, this is interesting. We haven't seen this pairing before. The 2 justices that agreed the most with each other last term were Justices Kennedy and Kagan, agreeing 95% of the time. Justices Scalia and Alito agreed 94% of the time, though of course that data was, you know, a bit marred by the fact that we don't have a full term of data. And then Justices Breyer and Kagan agreeing 92% of the time. Now, in terms of disagreement, I think a little more predictable. Justices Thomas and Ginsburg agreed only in 62% of the cases, and Justices Thomas and Sotomayor agreed in only 64% of the cases. A couple other data points in terms of who's in the majority the most. By and away, Justice Kennedy in the majority 98% of the time last term. The term before, we had something unusual with Justice Breyer being the justice most in the majority at 92% of the time. The justice least frequently in the majority was Justice Thomas, being in the majority only 72% of the time. On the other hand, Justice Thomas wrote by and away more opinions than any other justice last term. He wrote 39 opinions, separate opinions last term, including concurrences and dissents, of which there were many. In the term before, he wrote 37. So lots of separate writing coming from the chambers of Justice Thomas. The Chief Justice's chambers, by contrast, writing the fewest number of opinions, writing 11 opinions last term. And then in terms of which circuit is getting the most cases, like usual, the Ninth Circuit getting the most cases by the U.S. Supreme Court and getting reversed quite a bit of the time. So with that, let me start by talking about some of the cases, the commercial cases that are pending at the court this year. And I'm going to start with the visa cases. Just by way of disclosure, I'm arguing these visa cases in December at the court. And the next case I'm going to discuss, Bank of America versus City of Miami and Wells Fargo versus City of Miami, I'm arguing those as well in November. So take whatever I'm saying with a grain of salt. The visa cases. Many of you may remember that when you used to travel in the 70s, if you were alive then, that you'd have to carry these traveler's checks with you. And, that's how you'd get cash somewhere else. And it was a clunky, inefficient system. And banks started saying, well, we can automate this. We can create ATM machines. And the bank ATM machines generally worked at your bank, though. It didn't allow you to travel and get cash. And so eventually networks started forming of ATM machines. And so that you could go, if you lived in Chicago, you could go to Paris and use an ATM machine or something like that. And those were designated with various network bugs. So if you have an ATM card, you can see on the back, you see these little logos, Cirrus, Star, Allpoint. And those are just to signal the network that the networks that are available to you as a customer of a particular bank. So this all worked pretty nicely. These networks proliferated. And eventually, the rules were liberalized, and the people who made ATMs or who offered ATM services were allowed to be independent from any sort of bank. They could offer their own ATM service, and that's why you see them today in the 7-Eleven or whatever. They're not bank ATMs, they're independent ATMs. And they were permitted to charge individuals, as you all know. And none of us like paying those fees. But you see them every time. But they're obviously performing the service, the network, in making access to cash available. You don't have to go through the traveler's check and all sorts of things like that. So these networks develop, and independent ATMs want access to those networks. Visa and MasterCard owned two of the big networks, Cirrus and Plus. And what they said in 1996 was, look, if you independent ATM operators want to use our network and access to our customers and so on, that's fine, we'd love that. But we are worried that you're going to discriminate against our customers and charge them higher access fees. So as long as you agree to, they separately said this, as long as you agree that you will not charge our customers more than you charge customers of other networks, fine, you have access to our system. I'm not telling you what to charge. We're just saying you've got to, whatever deals you're giving some networks, you got to give to us. A kind of most favored nations clause kind of idea. And you would think that's what the case may be about, or most favored nations clause is anti-competitive, pro-competitive, whatever. But actually, that's not it. This is really about the pleading standards that are required. The Supreme Court, in a decision called Twombly a few years ago, said that you couldn't just allege, if you were the plaintiff, something that might conceivably be an antitrust violation. You got to show that it plausibly was one. So here's the plaintiff's theory. The plaintiff's theory is Visa and MasterCard. You were entities and you had corporate boards, and on your corporate boards sat members of various banks. And you banks were conspiring to basically hurt the independent ATM operators. And you were doing it through these joint agreements, like Visa, joint venture-like agreements, like Visa and MasterCard. So by being part of that association, Visa or MasterCard, and by Visa and MasterCard promulgating those rules, you banks were effectively acting through them. Therefore, you are fixing the price effectively of ATM access fees, and you should be held liable under Section 1 of the Sherman Antitrust Act. And what the bank said in response is, look, there were some members of the boards that were from the banks, but they all had fiduciary interests to Visa and MasterCard, their own separate entities. There wasn't any, thought, and there wasn't any proof, there wasn't any suggestion really that they were pursuing their own kind of, nefarious ends as banks and forcing Visa and MasterCard to try and fix prices or anything like that. Rather, they were doing what entities do all the time, which is protect their customers from price discrimination. So the DC Circuit said that was enough to go past the Twombly standard. The banks then and Visa and MasterCard petitioned for certiorari and obtained it on the last day of the term last year, saying basically that this is going to be a tremendously destabilizing force to businesses. And if you just think about it, I mean, joint ventures, companies engage in joint ventures all the time. And if being part of a joint venture is prima facie evidence or something that there's an antitrust violation, that there is an agreement to restrain trade, then it's really going to chill the formation of those joint ventures or business associations as well. And indeed, at the cert stage and now at the merit stage, there's an important brief filed by an association of associations. I didn't know that such a thing existed, but it does. And they argued very powerfully that if the rule of the DC Circuit were to go forward, that it would mean effectively a chilling effect on associations, because that could always be alleged by a plaintiff. And because antitrust investigations and discovery is so destabilizing, and because of treble damages and the like, there are real serious concerns in this area. So it's a really interesting case to watch. This is one that I think might really tell us a bit about the direction of the court post-Justice Scalia. It's a little hard to know at this stage what the other side's going to argue. Their brief's not in, but at least the cert was granted, even though it was an 8-member court, and so it's a very interesting case to watch. Also granted that day were a pair of cases, Wells Fargo versus City of Miami and Bank of America versus City of Miami. And these raise questions about the Fair Housing Act. So the Fair Housing Act is obviously one of our nation's most important statutes. And you all know the basic contours of what it says, which is that it prohibits discrimination in real estate transactions or transactions related to real estate transactions, getting a mortgage, things like that. Section 813 says who can sue under the Act, standing. And these cases are really standing cases that come to the court. They have had some big Fair Housing Act cases about disparate impact and the like over the last several years. This is a standing case. So Section 813 says that an aggrieved person can bring a suit. And it defines an aggrieved person as, quote, any person who claims to have been injured by a discriminatory housing practice or believes that such person will be injured by a discriminatory housing practice that is about to occur. And by the way, there's also a separate provision in the Fair Housing Act, Section 810, which allows the Secretary of HUD to ask the Justice Department to file a Fair Housing Act complaint. You heard a little bit about that last night. The city's complaint in this case, the two complaints in these cases, were filed by a plaintiff's side law firm and filed by various cities. They went around, I think, and asked various cities to file these complaints that adopted a pretty novel theory of who can sue. They're not suing on behalf of the victims of discrimination, someone who wasn't allowed to get a mortgage or something like that. Their theory is different. The theory is this, that the banks were engaged in discriminatory lending practices by giving subprime loans disproportionately to minorities. The minorities couldn't pay the mortgages on those loans over time. And so that led to a number of foreclosures. Once the foreclosures happened, they argue, people moved out of those areas, property values declined. Because property values declined, tax dollars to the city were reduced, and the city was therefore hurt. And then they have another theory, which is almost the same chains of causation. So banks engage in lots of subprime lending, disproportionately affects minorities. Minorities can't pay their mortgages. More foreclosures happen. More foreclosures mean lower property taxes, but it also means they say that they couldn't afford, they needed extra social services to cover fire and police and other stuff from the more vacant neighborhoods, and that injured the city. So this is a Fair Housing Act case, however. And so Wells Fargo and Bank of America have said, look, in order to have standing, you have to be within the zone of interest protected by the statute. And obviously, people who have been harmed, have been the victims of discrimination, they can sue. But the question in this case is, can someone outside of that, can they sue? Is the city properly within the zone of interest protected by the statute? So this is a really interesting case because there's kind of dueling lines of Supreme Court case law. Most recently, the Supreme Court 5 years ago, in a case called Thompson versus North American Steel, interpreted Title VII, which has the exact same language, person aggrieved. And what the Supreme Court in Thompson said is, well, person aggrieved can't mean that only the individual victim of discrimination can sue. Otherwise, they would have just said that in Title VII. So it's got to be something broader than what the company there was arguing. But the question is, how broad? They said it certainly can't be so broad as to encompass the outer limits of Article 3 and give standing to potentially anyone. Rather, it's got to be something narrower. And in the course of that, they said, we did decide this in the 1970s in 3 cases about the Fair Housing Act. The statutes are exactly the same. And the court says in dicta, the court went on in those 3 cases in the 1970s, and one was in 1982, but so within about a 12-year period. We did say that the person aggrieved extends to the outer bounds of Article 3. That was ill-considered dicta, and we decide not to follow it. Okay, so that's about Title VII. Supreme Court closes the door on this idea that Congress, by using the words person aggrieved in Title VII, means the outer limits of Article 3. So the banks go to the 11th Circuit and say, read Thompson, plain as day. It says these cases are dicta, ill-considered, and so on. In that it can't be that anyone falls within the statute. It's got to be, you've got to really show squarely that you're within the zone of interest. The 11th Circuit says, oh, not so fast. Those 3 cases from the 1970 to 1982 haven't been squarely overruled by the U.S. Supreme Court. And until they are overruled, it's not our job as a lower court to overrule them. And so, yes, their most recent pronouncement in Thompson, which dealt with Title VII and which borrowed from the Fair Housing Act cases and which said the statutes use the same language and we should interpret them the same way, the court hadn't connected the dots in Thompson with respect to the Fair Housing Act. They had only connected them with respect to Title VII, and so we, the 11th Circuit, find it's not our job to do so. Although they say the Supreme Court may very well, say that these cases should be overruled. It's just not our job to do so. So the banks filed cert petitions saying, justices, please connect the dots. And a court granted the case. And we just filed our merits brief for the banks last couple weeks ago, and we said basically connect the dots. And the other side hasn't filed their brief. It comes in later this month. But I think you can expect them to say something like the statutes have different histories or something like that. They should be interpreted differently. Somewhat tough argument since the court time and again has interpreted the two statutes in pari materia the same way. The Solicitor General did not file on our side. Did not file in either party brief, so the time for that has elapsed. So some people are thinking that the Solicitor General will file a brief on the other side, which is an interesting thing given the fact the Solicitor General's office traditionally has strong programmatic interests in narrowing standing, and in particular, narrowing zone of interest standing, because that's the same term used in the Administrative Procedures Act, and so it has some fairly large consequences. So it'll be interesting to see if there is a brief, what that brief argues. The next case that I want to talk about is State Farm versus Rigsby. And this is a key TAM case, and it involves Hurricane Katrina. And, in the horrible wake of Katrina, there were a number of claims filed for insurance. And the claims arose largely from either wind insurance, which State Farm has to pay out of its pocket, or from flood insurance. And if it's a flood insurance claim, it turns out it's paid by the government under the National Flood Insurance Program. And so the argument in this case is basically that State Farm had a kind of incentive to claim that stuff is actually damaged by flood when it's damaged by wind. And so you've got a house owned by Thomas and Pamela McIntosh in Biloxi, Mississippi, and Kerry Rigsby and another State Farm adjuster allege that they were told by their supervisor, quote, if you see substantial damage, it will be from water. And they say that a forensic engineering firm came along and said, no, this is really damaged by wind. And they claim that the supervisors said, no, you have to write down that it's damaged by flood in order to try and have the government responsible for the dollars and not State Farm itself. These individuals brought a suit under the False Claims Act, and they alleged that State Farm had submitted false claims and false records to the government to try and get this flood reimbursement. Now, the problem is that there's something called the seal requirement with respect to the False Claims Act. And what the False Claims Act says in the seal requirement is that a plaintiff must file a complaint in camera and refrain from disclosing it until the court orders it served against the defendant. And, sometimes this doesn't happen. Either mistakes are made or intentional stuff happens, and the complaint is released, as it was here. And the circuits have been split on what happens then. So in the Ninth Circuit, in a case involving Hughes Aircraft, the Ninth Circuit said that it doesn't mean if you violate the seal requirement that an automatic dismissal of the complaint has to happen. Rather, you look to the actual harm to the government caused by the fact that the complaint is out there and the nature of the violations, and you also look to their intent. Was this done intentionally or in bad faith? So kind of factor by factor analysis. By contrast, the Sixth Circuit has a bright line rule that says if you violate the seal requirement, the False Claims Act complaint has to be dismissed. And so the question of the case is which rule is going to win. State Farm, which filed their petition from the Fifth Circuit, which had aligned itself in their case with the Ninth Circuit, says text, text, text. The text of the statute says that a complaint, quote, shall be filed in camera, shall remain under seal for at least 60 days, and shall not be served on the defendant until the court so orders. And State Farm's argument is that Congress repeatedly used the word shall, indicating that the seal requirement is mandatory, especially given the fact that other provisions in the False Claims Act, they point out, use the word may. You know, this goes all the way back to Marbury versus Madison, shall versus may, all that stuff. So it's a long-running debate. They've got a pretty good argument on the text. They also have an interesting argument on the legislative history. Their version of the history, and it's contested by the other side, says that the False Claims Act was modeled on RCRA, the Resource Conservation Act, and that the Resource Conservation Act has a mandatory punishment of dismissal of the complaint if you violate the seal. And so that's the argument from State Farm. The argument on the other side is that shall doesn't always mean shall, isn't always mandatory. You don't remember that as well from Marbury versus Madison. And they say that the phrase under seal has a certain kind of term of art meaning for lawyers and judges, that the district court has discretion over whether to, when their seal orders are violated, what to do about it. And so by buying into that phrasing, they say they're buying into district court discretion, not mandatory must dismiss type arguments. And their version of the legislative history is to say that basically the whole point of the 1986 amendments and the seal provision was to empower private plaintiffs, to give them more power to bring lawsuits and to bring more false act claims, accusations, and lawsuits, and this would be contrary to that. Interesting case to watch, obviously the corporate community watching it very closely. Last case, and I'll do this fairly quickly because you know this case because you watch Showtime Billions. This is a case called United States versus Salmon. And it involves insider trading in 10b-5 of the 10b-5 of the Securities Act. So you've got a guy named Bassam Salman, and he's been trading on information passed by his brother-in-law, who has been providing him information, I think it was from Citibank's Health Services or something like that, without any personal benefit to him. So the Citibank guy is not getting anything out of this, okay, directly. No direct, tangible personal benefit. He's not getting a percentage of the profits or anything like that. And the question in the case is, can that guy be ultimately liable in that circumstance? In a 1983 case called Dirks versus SEC, the court said an insider trading prosecution, it requires a breach of fiduciary duty, quote, and if the insider personally benefited directly or indirectly from the disclosure. So the question in the case is, what kind of information is enough? The Second Circuit, in a case called the United States versus Newman, which was my case, so again, take this with a grain of salt, said that you could only have insider trading liability when there is, quote, a meaningfully close personal relationship that generates an exchange that is objective, consequential, and represents at least a potential gain of a pecuniary or similarly valuable nature. That you got to prove something, you really got something out of it. And there they said the government hadn't proved that with respect to Newman and Chasen, the two defendants, and so therefore the Second Circuit ordered them free. The government filed a cert petition to try and take the issue up. Cert was denied. And so those individuals are free. And Preet Bharara, the U.S. Attorney for the Southern District, nullified several other prosecutions in the wake of the Newman case, saying they were built on that theory of liability. Some of those prosecutions, as I recall, were decided by a judge named Jed Rakoff. Well, Judge Rakoff, never one to be shy, wound up sitting by designation on the Ninth Circuit. District Court judge sitting by designation on the Ninth Circuit. Happens all the time. Not always happens in a case like this, in which United States versus Salmon, in which he was able to write the majority opinion, disagreeing with Newman, the case that nullified some of the prosecutions that he presided over. And in the Salmon Ninth Circuit case, the court read Dirks broadly and found that, quote, when an insider makes a gift of confidential information to a trading relative or friend, that's enough to show insider trading liability. The defendant in Salmon petitioned the court for certiorari and said, you know, this is really vague and potentially open-ended. Pointed out that Justices Scalia and Thomas a couple years ago had criticized the whole 10b-5 oeuvre as basically made up, that there isn't a kind of direct statute that says that this is a crime. and has said basically that Salmon should be overruled and that Newman should be the law. The SG opposed certiorari, saying yes, and there was a tough opposition cert to Bright because of what they had filed last year, but basically said yes, there's some disagreement, but this isn't the right case to take. We won the case, the Ninth Circuit got the decision right, and so they were trying to hold the water and say, okay, we've lost in the Second Circuit, but we haven't lost elsewhere. At least that's my reading of what's going on. And so we're afraid we might lose nationwide, so let's try and block certiorari. An interesting strategic choice for the United States, which generally doesn't think that way. They generally think, hey, it's a circuit split. On an important issue, it's got to be decided. And particularly here, because after all, most of the insider trading prosecutions are brought in the Second Circuit, and the law is adverse to them. But my guess is that signals some view of what reception that they're likely to get on the merits when this case is argued in a couple of weeks.
Okay, thank you very much, Neal. Daryl, the floor is yours.
Thank you. Thank you. Sorry for the awkward entrance, just had foot surgery. This is why I'm hobbling a little bit. But good to see everybody. And Neal was talking about the last time we transitioned, which went seamlessly because he was the one taking the ball and being seamless after that. So I will try to be somewhat as good when the ball's going the other direction. But I'm here for the IP cases, so this year the Supreme Court's already taken 4 IP cases, 3 patent cases, 1 copyright. The amazing thing is that that's not amazing anymore. Until recently, you just didn't see many IP cases in the Supreme Court, and you saw no patent cases. The reason is in 1982, the Federal Circuit Congress created the Federal Circuit and gave it exclusive nationwide jurisdiction over patent law cases. So you didn't have the regional circuits doing patent law anymore. It was all consolidated in the Federal Circuit. And the Supreme Court, for whatever reason, just then completely took a vacation from the substance of patent law for about 25 or 30 years, during which time the Federal Circuit unified patent law with a bunch of very clear, generally easy to understand rules. A generation or 2 of patent lawyers grew up understanding it. Companies like, say, Raytheon were able to make investments knowing what they thought IP law was. And whatever you thought of what the Federal Circuit was doing, at least people knew what this area of property rights law meant. What's happened now is that this has all been upended over the last about 12 years. This was back when I was in the SG's office it started happening, but the court took a patent case after calling for the government's views first, then took another case after calling for the government's views. Then then it took 2 cases. It's trying this out, let's see what it's like. And it got to the point where a few years ago they took 10 IP cases in 1 year, 6 of which were patent cases. I think that was 2013 term. This year, again, less than half the cases taken for the term. We assume they're going to have a relatively full docket this year. They've already got 4 IP cases, 3 patent, which is getting to be the new normal. But as a result, the consequences, there's now a new sheriff in town, as the Supreme Court seemingly bit by bit through the Patent Act is just reworking patent law, which is great for appellate litigators because there are now lots of new ways to win cases that didn't used to be there before. You can change the law in ways that never would have worked before. And that's true in the Federal Circuit because they're paying attention to the Supreme Court, not just only in the Supreme Court. But obviously it's terrifying to clients because this is property rights and it's now hard to understand exactly what's patentable, harder at least to understand what's patentable and what the consequences of that are. In terms of this year's cases, the cases I think help tell the overall story of what the Supreme Court's doing. There basically have been 3 or 4 themes to the Supreme Court's cases that looks like these cases are typical of that. First, the courts repeatedly held that the same general principles of law that apply elsewhere also apply in patent law. The thing is, the Federal Circuit, because it just has exclusive jurisdiction of a few areas of law, had one frame of reference, which is focused on, say, patent law. A regional court of appeals, the frame of reference is the law generally. So if an injunction issue comes up, a regional court of appeals says, well, we have this 4-standard test that always applies to injunctions, let's apply it. The Federal Circuit side, it would say, well, this is a patent case. This is about exclusive rights. Let's come up with this test. And this happened consistently. You basically had 2 evolutionary paths of the law almost. The regional circuit's doing things, the Federal Circuit doing something different that was geared toward the patent context. the Supreme Court is now very much of the view that the same principles of law that apply elsewhere will apply here. So if it's an injunction, for example, it's the same four-factor test. If it's the standard for jurisdiction over a declaratory judgment action claim, same. Administrative law case, same as elsewhere. And these have all been reversals of the Federal Circuit. The second thing you see is the bright line rules versus flexible standards debate that we all learned in the first semester of law school. It's still alive and well. And this Federal Circuit created a lot of bright line rules. The idea was they were supervising a large number of federal district courts across the country, and they wanted clear rules. Everyone knew what they were, could apply them. It'd be much more administrable that way, especially with property rights at stake, where people do need to know what they're dealing with. The Supreme Court has reversed a lot of those now, replacing them with more flexible standards. Part of that comes about, and if you look at the cases, part of that comes about because of what we're talking about is, say, an equitable principle, like injunctions I mentioned before. Well, that inherently tends to not lend itself to bright line rules. Also, as a matter of statutory interpretation, the Supreme Court is quite willing to interpret statutes to just at face value. So if they use vague words like reasonable or substantial, the Supreme Court's more likely to say, well, there's not a bright line rule to be had under normal statutory interpretation principles. Drives patent people nuts because they really want predictability, stability. But the Supreme Court will read the statute to say what it says and figure that in this area of law, as in others, factual disputes will be worked out factually. It's just a very different point of view that's really changed the law a lot, and still is. Also, the Supreme Court has a bunch of older patent decisions that had lost much in the way of influence over the years as the Supreme Court had checked out of patent law. The Supreme Court has now been finding that it likes its older decisions and reviving them. And the Federal Circuit is now much more attuned to older, sometimes very old Supreme Court decisions than it had been. The final theme you see is just a policy balance. There's no question. People will debate where on the spectrum we ought to be, but with IP law, just like as with antitrust law, it's a balance. You need to protect for a variety of reasons. If you overprotect, bad things happen. There's no question. The Federal Circuit got much more protective about patents. The Supreme Court, on balance, is now undoing some of that. What you make of that, where you think it should be, is highly debatable, but that's clearly something else that's going on here. So turning to this year's cases, the first couple actually illustrate what's now a fifth theme, which is basically attempts to get around recent reforms. The Federal Circuit on its own has also implemented a number of important reforms on the patent law side. The Supreme Court has. So plaintiffs are now looking for ways to try to get around some of that, which is creating a bunch of second-tier issues that are now enormously important, but would not have been before based on where the law had been. First up, the Samsung-Apple case. This deals with damages in patent cases. The normal rule is that, and the problem comes in, the Samsung-Apple case actually does involve Samsung phones, but even if it didn't, I'd probably use this as an example anyhow. And the reason is, there are a whole lot of different technologies in here, obviously. If someone's got a patent on the microphone, okay, that infringes. Does the plaintiff get to recover all of Samsung's profits for the entire phone because the phone infringes due to the microphone? No, ordinarily. The reason being that you have to apportion profits to the scope of the violation. The scope of the violation there would be the microphone. There are also 100 other important things in here, obviously, probably many more. And that's now pretty well settled, again, in the Federal Circuit. The Federal Circuit's tightened that up. You had this crazy runaway and unpredictable damages awards. The Federal Circuit's now requiring real economic evidence of the actual value of the relevant feature. So what do you do to try to get around that? Apple said design patents. Most patents are just for something that's practical, like a phone that does something. You can also get a patent for an ornamental design. In this case, remember the original iPhones in 2007? Yeah, it's basically, it's a relatively small black thing. It's got the rounded bevel around the outside of the screen in the case. If it's on, there's icons you can push. If you have a patent, they got a design patent basically on that, which nowadays doesn't seem terribly new or interesting, but at the time, 10 years ago, it actually was pretty groundbreaking, right? So the reason that Apples can now would now choose to go on the design patent as opposed to on a patent on something more practical than the way it looks is that there's an old statute that says that if I apply a patented design to an article of manufacture, which basically means if I use that design on my phone, the owner is liable to the extent of his total profit, which is a departure from any other area of law, including the rest of patent law. So the point seems to be that you get the entire profit for the article of manufacture. So the game then becomes, what's the article of manufacture? Is it the cover of the phone, which is the design, or is it the entire phone? Because if the article of manufacture is the entire phone, then you get what Apple got from the jury, which is $1 billion based on the total profits of the phone as a whole, as opposed to the value added by the design. Strange thing happened. So the U.S. came in and said, okay, look, you do get total profits for the article of manufacture. But hold on. This is the U.S. brief. The U.S. tends to be pretty influential in this area. It says, but hold on, the article of manufacture is not necessarily the entire thing. I mean, even if you don't sell the design separately, even if you just sell the whole phone, doesn't mean the article of manufacture is necessarily this, because if there's different components, maybe the article of manufacture is just a component, and that's a factual question. And the government then has, about a 5-factor test for figuring out that factual question for a jury to look at. Here's what happened. Apple then came in and said, yep, article of manufacture is not necessarily the whole product that's being sold. It could be a component of it. Well, that's not what the Federal Circuit thought, and it's not the basis on which Apple had won. Apple's now trying to kind of reposition what happened below to say that it should win on the facts, which makes the case in some senses, it's still an important case, but in some sense it makes the ultimate legal result here relatively clear. There's still a question as to when you look at a component, when you look at the whole thing. The Supreme Court will probably agree with the government that there are a variety of facts to be considered on remand. But it does take this area of law and make it kind of murky, because no one seems to know when you look at the whole phone or when you look at part of it. But it also lends itself to, I think, probably a relatively minimalist opinion, in the sense of, okay, we all agree on a lot, and now we can remand for the lower courts to figure out more, is my best guess about what happens. Obviously, we represent lots of companies involved in these cases. I'm just giving my own views, not my firm's or any clients. And because it's IP, it's a guarantee that anything I say, some of our clients will agree with, some will vigorously disagree with. It's just the nature of IP.
Daryl, can I just interject with a question?
Yeah.
How does the government how does the SG's office come to its position, particularly as to which theory of damages it seeks to pursue and establish?
Yeah, so the government, I mean, in the Solicitor General's office, oftentimes before the court will take an IP case, they'll call for the government's views. Sometimes they'll take it without calling for views. Either way, the Solicitor General's office then runs a process that's designed to help to figure out what the government's view should be, which means consulting with everyone in the government. So you send out inquiries. If it's a patent case, obviously, to the Patent and Trademark Office, the Commerce Department, which the Patent Office is in, the competition agencies, Antitrust Division of Justice, the Federal Trade Commission. There are other interested parts of the Justice Department. If it's a medical case, you'll be talking to the FDA and HHS, and you get everybody's views on the law and the policy and the government's interests in what the decision ought to be. And then the SG's office, if everyone's in agreement, that's easy. Normally, you're trying to sort of broker something, which was my favorite when I was there, because if you had agencies vigorously disagreeing with one another, I figured that I should just do what I thought was right. But so it's a lengthy process where everybody gets heard out, and you try to come up with something that you think fulfills the government's interests, that you think you can sell to the Supreme Court, and taking the court seriously, as opposed to, but that also does jive with what the agencies are telling you is important to the government.
I think maybe I'm asking just a little different focus. Let's assume this is a battle between two companies or two industries as to how they determine damages. From whence derives the government's interest? Is it in how matters are resolved? Does the government have an interest because it has some ownership or IP interest in certain kinds of designs, et cetera? Or is it simply just a broker of political views about what should happen?
And that's the kind of situation where the government tends to not have much of a direct interest. So it really is then, if the court calls for its views, just acting as an honest broker. The court asks for our views, here they are. And so, for example, the government does get sued for patent infringement. So it does have a defensive interest in not paying too much when it's sued. But that's not, the government being the government, it doesn't give undue weight to its own defensive interest. It does tend to look more programmatically. We administer these statutes, what do we think the right thing is? Obviously, people disagree with that, but the principle is going in is almost never, well, we're sometimes defendants. It's more a matter of, what's right, and then you argue about that for a while. And so I was going to tie in something Neal had mentioned earlier about the Chief Justice making some headway with this effort to get more unanimous decisions out of the court. Obviously, the way you get more unanimity is through more minimalism, which is to say if you put less in the opinion, more people can join it, is part of what's been happening. And in patent law, that's been, in our IP generally, that's especially true. The Supreme Court seems to be happy to enforce legal rules somewhat minimally, go in and say, no, this rule doesn't make sense to us, this is what it should be. Leaving a lot to be worked out after that is what you oftentimes see. So it strikes me that Samsung v. Apple is probably one of those cases where there's going to be more to be worked out on remand. Relatedly, in terms of things that people are doing to try to get around the limits on patent protection, the distinction between copyright law and patent law is becoming really important. There's a fun case up there right now called Star Athletica about cheerleader uniforms. And the basic point there is you can't copyright the design of a useful article like clothes. You just can't, because it's useful. Maybe you can get a patent. You can get patents on all kinds of clothes, like the new, more weatherproof type clothes. You can't get a copyright on the design of clothing. But you can copyright a component that is separately identifiable from the utilitarian aspects of the article. So if you've got a component of the clothes that's separately identifiable from the utilitarian aspects, maybe you can. The classic example in an old Supreme Court case is if you've got a table lamp, you've got a really nice statue that forms the base of the lamp and then the rest of the practical stuff. You can copyright the statue, the design of the statue, because you could do that even if it was part of a lamp. Putting a lamp doesn't change that. But you can't copyright the lamp as a whole. With cheerleader uniforms, the government's view of clothing generally for a long time has been you can't copyright the design of the clothes. If you think of it as like just a colorless piece of clothing, can't copyright it. But if you put a design on it, sure, you can copyright the design. So for cheerleader uniforms, they say the design, the colors, the placement of the colors, the shapes, the lines, you can copyright all that. And that's been the Copyright Office's position for a long time. That's the question that's in the court now. And it's important, in this case, you may figure that sounds like about the right line, but the thing that's really hard is the test for when you can use copyright for things that have utilitarian value, because it gets around all the limits on patent protection. Where we're seeing it especially now is with computer software. Enormously important. It's getting harder and harder to copyright inventions that involve computer software. If you've got a standard computer, you're going to make it do something different. It's basically a software invention. Those are getting really hard to patent these days. So Oracle, Cisco, some others have started bringing suits where they're seeking copyright protection for aspects of computer code, structure of computer code, for example. And disclosure, the leading case on this is Oracle against Google. I represent Google. But it's becoming enormously important because the more the patent law gets tightened up, the more there's this inevitable desire to go to copyright or design patents, things like that. The other two IP cases they've taken so far for this term are both, in my view, kind of repeats. And the first one is very much along the lines of the Neal's Connect the Dots case. In fact, they should have said that. One of the sides should have said that in their briefs. The question is whether latches is a defense to patent infringement. And so the idea is setting aside statutes of limitations, setting aside statutes of repose, if a plaintiff unreasonably delays or brings suit and that causes prejudice to the defendant, does that mean that they can't sue because of latches, which is a defense that's generally available? So you might think it's generally available, it's available here. And in fact, in patent cases, it's always been understood by courts in patent cases that latches is an available defense. Until something funny happened, which is 2 years ago, in a copyright case, the Supreme Court held that latches is not a defense to copyright infringement. Now, the Patent Act and Copyright Act tend to be read the same way, especially on points like this where it's not obvious that there'd be a difference. By the way, WLF filed a brief in this case saying that latches should still be a defense. But so it's an interesting case because in the Copyright Act case a couple of years ago, it involved the movie Raging Bull with Robert De Niro and so forth. the issue there was that you look at the Copyright Act and it says no civil action may be maintained unless it's commenced within 3 years after the claim accrued. So 3 years after the claim accrued. Well, every time I show the movie, that's a new violation, a new claim. So the idea of the Raging Bull suit was, well, look, I haven't, I only want damages for the last 3 years worth of showings of the movie, basically. Yeah, it's been out for 30 years. Forget about the first 27. I just want the last 3. And the statute permits that. The counter-argument was, well, no, there's latches, too. And you wait 3 decades to bring a suit. I mean, come on, all the evidence is gone. Witnesses are dead. It's a classic instance of latches. But the Supreme Court held that, no, there's no gap to fill here by latches because the statute's clear. It says you just file within 3 years of when the claim accrued. And latches is generally an equitable defense. Here we're in law, not equity, which most people thought was long, long gone as a distinction for most things. But therefore, we're not going to presume that latches would apply. All right, you then switch over to the Patent Act. By the way, this has led to some interesting results, like the Stairway to Heaven trial. I remember earlier this summer, there was actually a trial, crazy trial actually, that I think the lawyer has since been disbarred, the plaintiff's lawyer has since been disbarred. But it was an old rock band from the 60s called Taurus, I think, thought that the Led Zeppelin song Stairway to Heaven infringed their copyrights. And so he had this great, I read about it in Rolling Stone, they had the best coverage of it by far. But he had this great copyright trial for a week with, Robert Plant, Jimmy Page, everybody there testifying. And it was permitted basically by this no latches decision. Because Stairway to Heaven, I mean, my God, pretty sure they wrote that a long time ago, right? It also turned into, in a weird way, a testament to why latches is a good idea. Because the Led Zeppelin people kept testifying persuasively, in my view, that they didn't remember ever hearing this other song before. They didn't remember any of this ever happening. Now, of course, there's a pretty good chance that they didn't remember much of anything from the period because one, their lifestyles at the time, but two, it was also a really long time ago and they're kind of old now. Which is why actually the plaintiffs actually wanted to argue that, yeah, the reason they don't remember anything is they were stoned at the time, which did not come into the jury. But you see on the copyright side now all these really old cases coming up with evidence in questionable condition. On the patent side, the patent statute contains language which the operative language is not much more helpful than you saw in copyright. It says, no recovery shall be had for any infringement committed more than 6 years before the complaint. No recovery for more than 6 years before the complaint. It's kind of similar to no civil action may be maintained unless it's commenced within 3 years after the claim accrued. So the question is, why does that not control in patent cases? The Federal Circuit, after Petrella, decided it did not govern because there's a lot of other interpretive evidence that suggests that there should be latches permitted in patent cases. The interesting thing is, the argument for latches is no doubt stronger on the patent side than on the copyright side. If you forgot that the two statutes are normally read the same way, you may well come to different conclusions about the two. But the question is this going to be one of these cases where, because the court saw it in a copyright case first, there's not going to be latches anymore in patent law. Whereas if the court first saw it in a patent case, maybe now there'll still be latches in copyright law. That's the question, basically. I think it's an interesting one about everyone has seen this. The timing at which issues get decided sometimes dictates how some of them are decided. And this may or may not be one of those. Finally, the other one that's a bit of a repeat, in my view, is Life Tech against Promega. This case deals with the extraterritorial reach of the U.S. patent laws. It's unlawful to make, use, or sell a patented invention in the U.S. Make, use, or sell. A long time ago, someone figured out the easy way around this for sales overseas, which is you put all of the parts in a box with instructions on how to assemble them. You send it abroad, and you structure it so the sale occurs abroad. All right, no one made it here because the parts were put together by somebody abroad. No one used it here, and you structure the sale so it occurred abroad. Congress thought that was kind of ridiculous, and so it enacted a statute that prohibits supplying a substantial portion of the components of a patented invention from the United States. So it's an exception to, in any event, in sort of the modern era, in 2007, of patent law, one of the early patent cases from the Supreme Court was Microsoft against AT&T. Disclosure, I read it broadly because this was one of my cases to the government, so we won it, I liked it. I read it for all it's worth. But the idea there was that Microsoft sent a single copy of software abroad. Abroad, the software would be loaded into a computer, and that's what was patentable. The software on the computer, not just the software. And it was a standard computer. So the question was, well, okay, if I send a single copy of the software abroad, the software gets copied abroad, lots of copies made abroad, lots of copies put in lots of computers abroad, sold to people abroad for use abroad. Does the sending one copy from here to there mean that every time any one of those derivatives is sold abroad, I'm liable back here? You could. I think there were reasonable arguments either way, but the main point is we have a presumption against extraterritoriality. Was the way I looked at it anyway. And under the presumption against extraterritoriality, the statute doesn't clearly say that it wants to ring you up for all that extraterritorial conduct because you sent one copy from here. The Supreme Court held the presumption against extraterritoriality applies, and you can be held liable for at most for sending one copy abroad, not for all the others that were made abroad. This case kind of gets back to that again. That's why I said it's a repeat in my view. This case involves a genetic testing kit that a doctor could use, obviously for genetic testing. It's got 5 components, 5 parts. One of them is supplied from the US, and that one is an enzyme that is a very standard basic chemical tool that biologists use for lots of different things. You could analogize if you wanted to a AA battery. Might be overstating it somewhat, but the point is, if I send a AA battery abroad and it gets put into something that then completes a patented invention, am I going to be liable for supplying a substantial portion of the components? And the Federal Circuit said, well, yes, because without that enzyme, the whole thing wouldn't work. So that one thing that it wouldn't work without is otherwise a substantial component. Well, it wouldn't have worked without any of the 5, right? My example wouldn't have worked without the battery. But are we really talking about a substantial portion of the components here? And the Federal Circuit held yes. And the thing is, you can make textual arguments pro and con. I think the much better argument is that a substantial portion of the components suggests you probably have more than one component. At a minimum, suggests that one, if you're down to one, that it's not a standard thing, it's the one that's inventive. But whatever you think about that, again, the presumption against extraterritoriality is key. Because under the presumption, the statute would have to clearly dictate the Federal Circuit's result. And I think it's best read otherwise. I don't see how it clearly dictates the result, which makes it, in my view, sort of a redo of Microsoft in that respect. And it also then puts this in the bucket of general principles of law apply. The Federal Circuit is looking at this in terms of patent policy principle. Federal Circuit historically, is focused on the patent side of things. The Supreme Court's looking at general principles of law. So the presumption against extraterritoriality seems to have more play in the Supreme Court than in the Federal Circuit, because the Supreme Court, perhaps because the Supreme Court's used to saying the presumption against extraterritoriality a lot. So that is the cases they've taken thus far for this year. There may well be more, obviously, but it all, again, seems to fit into the sort of the framework I discussed earlier. Whichever way the cases come out, it's sort of the same set of considerations, jurisprudential considerations that you keep seeing over and over again. Thanks.
Thank you, Daryl. We have just a few minutes for questions. I have a couple just to lead off here. Welcome any questions from those of you who are here, and obviously questions from anyone online. We'll be delighted to entertain those. Again, Neal and Daryl, thank you both very much for your astute assessment of those cases. I'd like to go back to maybe some of the comments you made at the outset, in particular, Neal, but I'd like both your reflections on it, since you've shared some common experiences. And that is, could you elaborate a little bit more on your sense of what the impact of an 8-justice court will be over the next several months, and how that could impact the docket, in particular, whether that might have some impact on the kinds of cases that Washington Legal Foundation would have an interest in, or any other general thoughts about what you're seeing there, whether there's any equivalent period that you might reflect on historically of how the court responded and reacted in those circumstances.
Yeah, well, let me just start there. I don't think there's any historical analog for this. Waiting 200 days with a shorthanded court, and it's really dramatically impacting the court's business. It affects, in the cases that they had already agreed to hear. You take the Texas immigration case affecting, millions of people, and, I don't care which side you might come out on that case. The fact is that case was deadlocked 4-4 with no opinion by the court, and all of these people left in limbo. And that just seems like a real horrible thing. The court is there to settle big, huge disputes on which the country is divided. And it can't do its job in some fraction of the cases because the court is evenly divided 4-4. So those are the cases that they have agreed, that they had already agreed to take. What are the effects of an 8-member court on cases that they're thinking about taking? Well, I think the effects there are pretty profound too. They have certainly numerically taken almost the same number of cases as they had in prior years at this point. But the composition of the cases is really different. I mean, this month is the court sitting that begins next week is almost entirely criminal cases, which are important, of course, but so too, and we're here at WLF, which is dedicated to thinking about the commercial cases. The commercial cases are really suffering. I mean, I just give you one example. I filed a cert petition for Google last year in a big class action case involving Walmart versus Dukes, and the courts are very, very divided on how to understand that decision, and then another decision called Comcast versus Aaron. And lots of industry want answers to what are the rules in class action cases now. And it's pretty much, I told my team, I think this is the easiest cert petition I've ever written in my time as a Supreme Court lawyer. It wrote itself. It was so easy. And yet the court denied certiorari. And I think we're seeing that time and again in a bunch of the cases. Not in every case. Obviously, as Daryl's talked about some important IP cases they've taken. I've talked about some important, antitrust and other cases. But it's certainly having an impact on cases that they're taking, and particularly for the stuff that WLF cares about.
Daryl, do you have any reflections or comments on that?
I tend to be mildly contrarian just for the fun of it. But what I especially wonder about, always with the Supreme Court, is just sample sizes. In the sense that there have been terms where it started off looking pretty boring and got real interesting real quick. So far we've only seen, we hope, about a third of the course grants. Find out. Most people know on Monday the court conference is about 3 months worth of petitions, and we'll should find get the grants from those pretty soon. Quite soon, in fact. And if that set of cases looks like the set of cases they have now, that puts you in one direction. If there's actually some other dicier cases on there, then or cases that we'd rather talk about on there, that might push you in a different direction. But there's no doubt that with 8, it has an impact. Of course it has an impact. But how much of an impact it's having? There are a few high-profile cases where it obviously had an impact. I mean, the contraceptives case last term, they basically remanded for settlement discussions, which, whatever else you thought, I didn't even know that was even one of their options. And the immigration thing, yeah, I agree. I mean, you need something other than affirmed by a court, one particular court of appeals. And so, in terms of how much of an impact it's having, I think that we will see. But obviously, the ones that could be controversial to fight for, there's a disincentive to taking them now. But we'll see how strong it actually is, especially after the next batch.
Neal, just to follow up on that, you had some data, statistics regarding last term and the court's decisions and actions. Any reflection on how this term might compare to that?
Yeah, well, I think I definitely agree with Daryl. Early in the term, it's only about a third of the grants are in or so. So we don't have a huge data set. But the cases that have been granted, as I say, tend to be criminal cases. They tend to be minor statutory cases involving the interpretation of some smaller provision rather than, the big meaty issues. I'm sure the law clerks there are kind of bummed because they came in thinking they were going to have affirmative action and, religious freedom and contraception, and instead they've got, for paragraph 42.9, subparagraph 3 of 18 U.S.C. something or the other. But, that's okay. Those cases are important, and the court will perform its function. I do think that these are institutionally minded justices, and that's a lovely thing. But I do think when they're thinking about voting, they're probably also thinking we owe it to the institution not to be deadlocked 4-4 in the cases where we can avoid it. And so if we're 4-4, if it really looks that way, let's not take that case. Now, it's not always that they're deadlocked in the predictable kind of Republican appointee versus Democratic appointee ways. I mean, I really see a kind of emerging centrist bloc at the court developing with the Chief Justice and Justice Breyer and Justice Kagan. And I think we'll see more and more of that. Either way, whatever happens with that 9th seat, I think we're in for some interesting coalitions.
Just one other general area. Both of you obviously served in the SG's office for a considerable period of time. Didn't overlap, but I'd be interested in your reflections just briefly in terms of how the SG's office functions, how it makes decisions, how it reacts and relates to the court, and whether you've seen any changes over the last 10, 12 years in that regard.
Yeah, sure.
Okay. Well, I think that Daryl described the process during his opening remarks. So when you have a case, you try and canvass all the government agencies and get their views on the case. One other thing, though, that maybe went over a little too quickly, you also bring the parties into the case. And so both sides. And when you have a case granted by the Supreme Court, or if the court has sought the views of the Solicitor General as to whether to take certiorari in a case, office tradition is both parties get a 1-hour meeting with the SG's office staff, as well as with the relevant components of the federal government. And you sit around, and it's like an oral argument. You ask all sorts of questions. If you're part of the government or if you're representing one of the parties, you're answering all the questions. And it's a really, really terrific process. When I was in the office and when I headed the office, it was very important to me to take the office traditions really seriously. And so that meant not just on process, but also on substance. That is, we didn't deviate from what the Bush administration said in cases, much to the consternation of the White House at various times, which is expected. But that office has a special, unique responsibility to represent the interests of the United States. And those interests don't change much from one administration to another. What does change is the inputs sometimes that come in. So, as Daryl said, you get all the federal government agencies who are sitting around the table. They're also sending you these memos. And the memos are written by the secretary of each agency, and those are politically appointed. So, for example, in the gene patents case that I did, in which we had 24 different opinions from 24 different federal agencies, some of those opinions were different than what the agencies had written years before because the agencies had changed politically. And you have to evaluate that as well when you're sitting in that chair. It's a really interesting process.
Yeah, it is. Because, the idea is to protect the long-run institutional interests of the United States. That's basically the buzzword. That's what you're there to do. And you do that by, generally speaking, by looking to defend policymakers' discretion and prerogatives, which means that you're generally looking to maximize discretion for people who are there this year and people who are there 10 years from now to do what they want to do. It's sort of a basic guiding light, and in my view, 90% of the time, 80% of the time, that'll tell you what the government will likely argue, as long as it's there's a good legal argument behind it. And when you stick to that, I found it to be much of a relief because some of these decisions are very hard, and that got me out of a lot of otherwise hard decisions because it's what I'm supposed to be doing anyway. With the others, obviously there's some. Voting rights is obvious. I think there are 1 or 2 voting rights issues where, as far as I can tell, every time there's a change in administration, there's a change in the government's position, and those are embarrassing. But you keep those to a minimum because they're embarrassing. But Neal's right that on some of these issues, the input you're getting from the agency may have a lot to do with who the president is, and that can then drive you toward one view or another if the government's institutional interests are not otherwise obvious, and if there are legal arguments that can either way. The one other thing I was going to make about these meetings is I loved them when I was in the government because you could just cross-examine the parties and have great fun with it. You know what I'm sure you've discovered now too is that if you're the one presenting at a meeting, it's basically like doing a Supreme Court argument that's twice as long as a Supreme Court argument. It's grueling. And a little bit ago, I had them on back-to-back days for different cases and discovered I'm not going to do that again because by the end of the second one, my brain was getting mushy because it's the intensity of it. It's unbelievable. The SG's office is super well prepared. Other people in the government are super well prepared, and it's this rapid-fire Q&A where you prepare so hard for them because you're basically going to do your Supreme Court argument for twice as long in front of a really knowledgeable audience. So it's a fascinating process that you don't public doesn't have a lot of visibility into. But it's a very good point that the government's not going to call and usually ask if you want a meeting. If you want one, you can call, they'll give it to you. So if you do have a case, make sure to call, because it's a great way to provide input.
One last question from me. This doesn't relate to the cases you just discussed, but from your position in the SG's office, I'd like your view on this. There's a lot of writing, a lot of discussion about the growth of the administrative state and the issue of courts' deference to agency decision-making. I suppose one could articulate that the SG's office may be seen as the defender of the government, almost always, or in many cases, or defender of agency decisions and actions. So what is your sense about that issue, where it could be going, and the vitality of that issue, and I suppose any concern about the growth of the so-called administrative state?
I think you're right. The government is in favor of the government. And so as the administrative state grows, the SG's office is there to protect the long-run institutional interests of the United States, which means if someone wants to come up with a new agency and staff it in a certain way, good, let's go defend it as long as there's a reasonable way to do it. And so it's, there's certainly not a check there on the growth of the administrative state.
I guess I'd say two things. One, that I think when we all hoped Justice Scalia would stay alive, and he was on the court, I think there was a real view that big issues like Chevron deference, or certainly our deference, were ripe to be rethought. And now we're just not sure exactly where the court is on those issues. We can speculate. At least Judge Garland, as a lower court judge, has been pretty deferential to agencies using Chevron. But it's hard to really know what's going to happen with that 9th seat, or what any replacement would do once they're actually sitting in the chair. So you have that's one set of kind of concerns, composition of the court. The other is kind of the dysfunction in Congress. And that's plaguing both administrations, Republicans and Democrats alike, where, unfortunately, a lot of times all they can get done is declare something like National Chicken Day or something like that, instead of solving some of the big problems. And so that forces presidents of both parties to use the agency structure more to decide big, important things. And so, as they're forced to decide those big, important things, the impact of deference grows. And so if that trend continues, and I sure hope it doesn't, but there's a good betting odd that it might, you're going to, I think, see a lot more pressure placed on the deference doctrines.
Questions from the audience here, or questions online?
Tony Morrow from the National Law Journal. And Neal, I jotted down when you discussed the State Farm case that you had a legislative history argument, and it just occurred to me that that's the kind of argument Justice Scalia would have not been happy to see or hear about. And I wonder, with him gone, is legislative history coming back as an argument, or maybe other areas that or do you shut that down?
Well, all sophisticated advocates always made a legislative history argument, not just if you could, not just in the briefs, but at oral argument. But you'd always have the phrase, you'd say, the legislative history, for those who look at it, says X. And you'd be looking right at Justice Scalia, because if you didn't say that, he's going to get into a fighting match with you about whether to look at it or not. So that was kind of the talismanic phrase you used to avoid it. But you always push legislative history because the Chief and Justice Breyer, among others, tend to look at it. So I do think it might have a little bit bigger impact now than it did otherwise. But, look, I think Justice Scalia revolutionized the way that we think about statutory interpretation by saying the text is the text, and that's, our starting point. And that's a huge impact, and that will continue no matter what, because I think everyone now buys into that. The question is, if the text is ambiguous, can you look to the legislative history Justice Scalia said no because it's drafted by, committee staff who have their own agendas and so on. It hasn't been democratically passed. He was very suspicious. Others have said, well, no, it could actually be illuminating. Certainly Justice Breyer has, written a lot about that.
Other questions?
Steve Wood from Schuhack and Texan in Chicago. Neal, I had a question for you about the Salmon case, and I found it fascinating that Judge Rakoff had an opportunity to influence the development of the law in the Ninth Circuit when he disagreed with the developments in his own circuit. And I assume it was a unanimous opinion, the Ninth Circuit's opinion. Do you know?
I think so. Yeah.
And do you happen to know whether there was any petition for rehearing en banc that the defendant pursued?
I think there might have been a petition for rehearing, but I can't remember. I mean, there's been some insinuations about this, about Judge Rakoff doing that. There's no evidence of that whatsoever. Look, he got sapped by designation. He got picked to do this. He did his job. So I don't think, there's any problem with what he did in terms of procedurally. Substantively, he adopted a view of the law that I think is pretty hard to sustain at the U.S. Supreme Court.
Right, okay. Well, it's interesting to know your view on the likely outcome of the Supreme Court's consideration of the merits. Of course, you do kind of wonder, what was happening, if anything, behind the scenes, and whether or not he was lobbying for an opportunity to write the opinion or, that sort of thing to influence the
Again, but judges, if you're within the group of three who's designated on a panel, judges all the time lobby with one another to do that. There's nothing improper about that.
Right.
There have been some blogosphere speculation that he lobbied to get on the panel in the first place.
Okay.
That would obviously be improper. We've certainly read about, some instances, high-profile instances of that, but there's zero evidence to say that's happening here. It doesn't meet the Twombly standard.
Sure. Right. Okay. Thanks.
Other questions? Anything online? Mark?
Neal, a follow-up to that question. Without regard to the Newman case in particular, or Judge Rakoff's situation in the Ninth Circuit, do you think that there should be a rule that would in some way prevent a district court judge who is sitting by designation in another circuit from either sitting on a case or at least writing the opinion that would be disagreeing with precedent in their own circuit? Do you think there's anything unseemly about that, or do you think it happens so rarely it's more just amusing than anything else?
Yeah, no, I don't think there's anything unseemly about it. I think it's a judge doing their job. I think if you did a rule like that, it'd invite all sorts of satellite litigation over whether or not it was really directly related, the prior position was directly related to the case at hand, how much it might disagree with the circuit precedent or so on. It'd be a disaster, I think. So, no, and plus, I think we're all better off when we have judges who've thought about issues. There's nothing wrong with that. And we want judges to actually have, clever and deep thinking and bring it to bear on a task.
Any other questions? Okay, thank you all very much for participating and coming. Thank you, Neal. Thank you, Daryl. Delighted that you both were here. Exceptional presentations. On behalf of WLF, thank you all for joining us this afternoon.